Okay, thank you. JHMB versus Charles Bernard. Thank you.
Yes, good morning. May it please the Court, John Shugan, Juan Farage, on behalf of the appellant, I'd reserve 3 minutes for rebuttal.
Good morning.
Notwithstanding the interesting background facts of this case, we maintain that the specific error that was committed below is very simple. Specifically, the trial court erred when it looked outside the four corners of the complaint, the third amended complaint, and dismissed the specific performance count, dismissed the declaratory judgment count.
But you're here on the discharge of the Lis Pendens.
Yes, we are.
So are you saying that any time there is a statement of the cause of action in the complaint for specific performance of an interest in realty, that the court must maintain a Lis Pendens?
No, we're not, Your Honor.
So in other words, they have to go to the merits of the claim, just like it's an injunction. In an injunction, you either grant or not, and one of the key factors is the likelihood of success on the merits.
Your Honor, that is correct. But
why isn't this entirely justified by the fact that it was extremely unlikely that you were going to get specific performance, particularly when you wanted specific performance only in accordance with your unlikely interpretation of the lease, sub-lease.
And I'm not avoiding the answer to the question.
Yes, right now I know that you are.
No, there's one.
If you say I'm not doing it, I know that you are doing it.
Your Honor, there's one fact that I believe is relevant, and that there was a duly recorded instrument in this case, the memorandum of sub-lease.
There was a duly recorded instrument. There was a duly for breach of the lease, for damage, and a case for damages, for breach of the lease. That was a duly recorded instrument, but you wouldn't be entitled to a Lis Pendens.
Correct, Your Honor, but we specifically...
The fact that it's a duly recorded instrument and your claim arises out of it doesn't make it subject or proper for a Lis Pendens.
Well, there is case law to support our position, including the LaRoche case, but what we would maintain, Your Honor...
Are you saying, not to avoid the answer, are you saying that the trial judge abused his discretion in concluding, if he did, and as frankly I would conclude, that there is a very small, if minuscule, if non-existent, likelihood of your success on the merits?
We believe that the trial court abused his discretion when he discharged the Lis Pendens without recognizing that this action was founded upon a duly recorded instrument, or without holding an evidentiary hearing.
Well, he discharged, Judge Adrian discharged the Lis Pendens because, based on the record, it was his judicial philosophy.
It was Judge Cueto. We had three judges in this case. The first judge was Judge Adrian. He had the evidentiary hearings. That was before there was even a specific performance count. We had Judge Butchko. She essentially...
Well, it doesn't matter who had what the personality was.
In response to your...
And the fact is, you wanted to have a specific performance of the lease as you interpreted it, just as you interpreted it. And that was the issue as to whether there was a breach of the lease or not. And you wanted to have a specific performance of a requirement, which is not in the sub-lease, that they produce powers of attorney, correct?
That was one.
If that were true, even if that were true, which it isn't, but even that was true, wouldn't, in granting specific performance, wouldn't the court have to supervise the production and the sufficiency of the alleged powers of attorney?
No, Your Honor. We maintain that this is no different than either a lease with an option to purchase, or, for example, a purchase with a money purchase.
You know exactly what is required in that case. You don't know what is required in this case. You have to win the issue of what you say is necessary. Besides that, is there any showing that you were ready, willing, and able on any terms?
We
Is
certainly...
there any showing?
The four corners of the complaint, Your Honor, and we never got past the motion to dismiss. That is... Your Honor,
this is not the motion to dismiss. This is, of course, if it were the motion to dismiss, you would have absolutely nothing. But you have not appealed from that, nor could you.
Procedurally, Your Honor, just...
Nor could you. The only issue is the propriety of a discharge of the Lis Pendens.
We did raise in our initial brief...
Isn't that correct?
That is the initial brief, but we did...
That is what you appealed from.
No, but we also asked this court to treat the denial of the motion to amend, which was without equitable adjustment, as a petition for writ of certiorari, as the Second District did in Vermont Lake.
We don't hear orders on motions to be dismissed by certiorari. That would destroy the entire non-final appeal rule.
We gave you the authority from Vermont Lakes, and obviously you're under no obligation to follow it. But on the issue of the discharge of the Lis Pendens, there are two cases from this court in which two of the three panel members participated. The first is LaRoche versus Your Honor and Judge Lagoa.
Well, we don't pay any attention to that.
The first is LaRoche versus Nahama, 948 Southern 2nd, 850. The second is Perdomo versus Cabrera, 963 Southern 2nd, 736. LaRoche was a case where the court held that the prospective purchaser was entitled to maintain a Lis Pendens because it was based on a duly recorded memorandum of option. In the Perdomo case, decided right after...
There are 15 other things that are involved in this case besides that. Go ahead. What's the other case then?
The other case is Perdomo versus Cabrera. It was decided 5 months later.
And who was on that?
You were on that, Your Honor. And in that...
Now you're talking.
It said, and I'll just quote this, in the present case, the action is not founded on a duly recorded instrument or a Chapter 713 Part 1 lien. That being so, the court was authorized to take evidence. So, and it distinguished LaRoche on the basis that that was based on a duly recorded instrument. So our position is...
The action for money damages is based on a duly recorded instrument, isn't it?
Yes, it is, Your Honor.
But that doesn't do it. You have to have some valid claim.
Correct.
That goes to the property, to the real estate. And if you don't have such a claim, whether it's in a duly recorded instrument or in the Magna Carta, it doesn't matter.
But the duly recorded instrument also recognized that the subtenant was granted with a right of first possession and a right of first offer with respect to the property. So we believe that this case squarely is a case founded on a duly recorded instrument.
And it's publicly recorded. That's the distinction. It's not that you entered into the memorandum. It's also that it was duly recorded in the public record.
Absolutely. And, Your Honor, I would submit to you that there is no evidence...
If you have a specific performance case that has been dismissed as not a specific performance case, you cannot get a Lis Pendens even though you are claiming it on a duly recorded instrument.
Correct, but there was no evidence that we were not ready, willing, and able.
But
we would argue that the discharge of the Lis Pendens was inappropriate because it was
therefore
predicated...
you want it to be reversed.
Yes, Your Honor.
And is that the actual release that you're seeking, the reversal of the dismissal of the Lis Pendens?
We are seeking reversal of the discharge of the Lis Pendens.
Thank you.
Thank you.
Thank you, Mr. Sheba.
May it please the Court, Michael Heiger and Colleen Del Totino on behalf of the Appellee, Charles Bernard. The trial court correctly discharged the Lis Pendens. And I'll just go right to that point because the issue of the... Mr.
Heiger, can you address, can you distinguish the LaRoche and Perdomo cases for us?
I can, Judge. And if I may, because I'll address all part of this one point of the argument, which is this. The memo of lease argument was raised by the appellant for the first time in its reply brief. I'm not saying it wasn't addressed below, but it was addressed as an ancillary point, as a throwaway point.
Get to the merits.
All the cases, including the LaRoche case that the appellant cites in support of its position, are cases that predate a 2009 revision to the Lis Pendens statute. The Lis Pendens statute was changed in two significant respects. One, it was changed and the statute is 48.23. It was changed in two significant respects. Subsection 2 now provides not only that the Lis Pendens only exists for a year, but that it actually expires after a year. Albeit that if it's based on a duly recorded instrument, it doesn't do so. But subsection 3, which is the critical section here, and if the court allow me to read it, it makes two significant changes to the language of subsection 3. The statute used to read when the initial pleading, and now it reads when the pending pleading does not show that the action is founded on a duly recorded instrument or on a lien claimed under Part 1 of Chapter 713, or when the action no longer affects the subject property. That language I just read, or when the action no longer affects the subject property, has been added to subsection 3. The court shall control and discharge the recorded notice of Lis Pendens as the court would grant and dissolve injunctions, which is to your point, Your Honor. And so here, the court clearly, and you have to look at the record that was well established, even though this case came to the trial court on motion to dismiss in a very unusual posture, because it was more than 2.5 years after the commencement of the complaint, and 4 amended complaints, none of which were precipitated by an order of dismissal, but all were, every time a motion to dismiss was filed, the plaintiff filed a new motion to amend. And finally, even on the eve of the hearing on the motion to dismiss that was ultimately heard, the plaintiff filed yet another motion to amend to have a 5th version of the complaint considered, and the trial court said, no, we're going forward with the hearing. And so, and even though it came to the court on that posture, it wasn't as though there was no labor in the trial court, because if you look at tabs 5, 7, and 8 to the appellant's brief, there were multiple evidentiary hearings in which the court had made significant rulings, which clearly the court, Your Honor, has noted, which shows that there's no chance that they're going to get specific performance here, because clearly, and consistent with decisions that Your Honor has been a part of the panel, Siegel, which relies on the dealer case.
Who are we talking about now?
I'm sorry?
What judge are we talking about now?
Judge Rothenberg, I'm sorry.
I don't feel like that. Go ahead.
Yeah, the court recognized the Supreme Court's firmly established principle that we only compel specific performance on precise terms of the contract. We don't rewrite the contract that the people entered into. And we don't do that even if we think the terms that they entered into are ineffective. And here, the trial court, in multiple orders, after multiple evidentiary hearings, had determined that every single thing that my client had done was proper, that it had fully performed.
Let me ask you a question, because under the statute that was amended, it specifically says in paragraph 4 that this section applies to all actions now or hereafter pending in any state or federal courts in this state. When was the action filed?
The action was filed in September of 2009.
And when did this take effect?
In 2009, the month I can't tell you to be July, I'm told.
July? Okay.
So, in addition, even if they wanted to rely on 48.23, the memo of lease argument.
You know, that's what I was relying on, because I don't recognize anything after 1917.
They can't do so, because what they filed their Lis Pendens in December of 2010, more than a year after the action was commenced, and clearly just another attempt to be dilatory and not actually perform.
Was there a bond?
No bond. And what's more, if you look at the Lis Pendens, which is at tab, I apologize, but it's attached to their appendix. It's not, their Lis Pendens makes no reference to the memo of lease at all. It relies on their specific performance claim. And even more, what's left in the trial court is a breach of contract action on a lease, not on a recorded lease. Yes, of course, they filed a memorandum and they're attaching the lease, but that's not what their action is based on. Their action is based on whether or not the lease itself was breached. It's not like a foreclosure on a mortgage where your action is founded on the mortgage. So it's clearly not founded on the duly recorded instrument, and so that argument is unavailable.
Have you moved for review of the portion of the order staying it?
We did not. Our position is that this court should affirm the trial court's decision discharging the Lis Pendens, and then immediately upon mandate, we'll ask the court to dissolve the stay, which the stay, obviously, without going outside the record, obviously has a tremendous impact on the redevelopment of the property.
That's why I asked. It has a significant and critical impact.
Then why didn't you seek review of the stay order?
We are trying to resolve those issues outside the record in business ways.
You're right, there seems to be enough work. And in conclusion?
No, Your Honor, other than simply, we respectfully request the court to affirm the trial court's decision to discharge the Lis Pendens.
Thank you. Thank you, Mr. Hager.
Again, putting aside the significance of whether this was based on a duly recorded instrument, it's our position that had the court sought to discharge this Lis Pendens like it would an injunction without having an evidentiary hearing, that would be error. And that's exactly what happened in this case. This was a motion to dismiss. It was noticed as a motion to discharge. The court looked beyond the four corners of the complaint, accepted the defenses that had been raised. There was no evidence presented, no sworn testimony that was presented, and we believe that that is what makes this significant as it relates to the discharge of the Lis Pendens. Let me also make it clear that we filed a motion for extension of Lis Pendens in an abundance of caution, where we specifically noted that it was based on a duly recorded instrument, but in the event that it wasn't, we were going to seek the court's permission to extend it. This was Judge Fudgko. There was an omnibus order.
I can't pay any attention to that.
Okay, sorry, Your Honor. There was an omnibus order. The omnibus order, which was agreed to by Mr. Hager's predecessor counsel, specifically said that the motion for extension of Lis Pendens is granted without prejudice to defendant's right to file a motion seeking dissolution or discharge of the Lis Pendens. Plaintiff fully reserves the right to oppose any such motion by the defendant. I would also
submit... What does this have to do with anything?
What it has to do with, Your Honor, is that they never properly sought to discharge the Lis Pendens as it would be an injunction. Having an evidentiary hearing evidence, determining whether we were this court has no evidentiary record to determine whether we were or were not ready, willing, and able to perform. Lastly, I would cite the two cases...
So we have nothing to tell us about your requirement for powers of attorney or anything like that.
Well,
we can't consider that.
There was one evidentiary hearing.
Can we consider that or not?
You can consider it, but I think it's important to recognize that our specific performance count wasn't even pending at the time, and that there was no testimony on the ready, willing, or able at the time in which the Lis Pendens was sought.
And so you wish to be affirmed? No. You don't wish to be.
We would like the trial court to be reversed. And let me just cite for the record two cases, Petro versus Fulton.
You don't have to cite cases for the record.
Well, to establish...
Are they in your brief?
Yes, they are. And the Petro case...
Can you take a hint?
Mr. Shubin, I'm interested in your argument.
It interprets the Lis Pendens statute as applying to actions in which the right of possession is sought, not just in which ownership is sought. Clearly, this leasehold would have given us a possessory right. We believe the Lis Pendens was appropriate, and we believe it was discharged inappropriately. Thank you.
Thank you. Thank you very much.